Hi everyone, and welcome to part two of the Suitable Alternative Employment quadrilogy. Today we're focusing on how suitable alternative employment is actually offered, looking at pools of employees who may be potentially interested in vacancies, and the concept of the trial period. Um, First and foremost, as we said in the previous video, we must ensure that all potentially redundant employees are made aware of any vacancies, and we need to consider how we're going to choose between employees when selecting people to be offered alternative roles. The Employment Appeals Tribunal has made it clear that we're not expected to adopt the same rigorous approach as is required in a selection process for a redundancy exercise. So this is not a case of having to go through a very detailed scoring process based on skills, qualifications, experience, training, that sort of thing, but we do need some fair process for deciding who to offer employment to. In Samsung Electronics, the Appeals Tribunal said good faith assessments of an employee's qualities are not normally liable to be second guessed by an employment tribunal. They're not going to conduct a forensic examination into an assessment if on the face of it we have some objective way of selecting them for that particular role. So we firstly need to look at how to alert employees to potentially available jobs. If there's only a few people at risk, we might decide to communicate with them individually, speak to them as part of the individual meetings. If we've got a larger number of potentially redundant employees, we might be looking at the intranet, notice boards, job boards, that sort of thing. For evidential purposes, it would be helpful though to write out to employees to confirm those vacancies, even if that is a precedent letter which goes to everybody. We must remember that if an employee has been made redundant, their expectations may well be refocused. They may well be looking to do any job whatsoever. So we are well advised to even look at offering or potentially making available jobs of lower status to those employees. And we should also be prepared to discuss the possibility of part-time work, self-employed contracting, get inventive really, and particularly if the employee may flag that as an option, it's something that we should be considering. So what happens when we are choosing between employees for particular jobs? Firstly, we must remember that employees who are on maternity, adoption or shared parental leave do have an automatic right to be offered suitable vacancies. I won't go into significant detail about that within this video, but it is likely that protection for employees on maternity leave will extend to the point in time where an employer is notified of pregnancy until 6 months after the end of maternity leave or adoption leave in those circumstances. We then need to make arrangements for potentially redundant employees to be considered for vacancies. So do we set out a timetable for applications? That's probably helpful to keep it on track. We are likely to want to hold interviews for those roles in order to select candidates for those roles. Importantly, those vacancies should be ring-fenced to the employees who are at risk at the time. There are cases that have focused previously on vacancies which have actually been offered to the whole workforce rather than just the potentially redundant employees. And the tribunal's been clear in stating that that does not reflect good industrial relations practice. So if you have vacancies, ring-fence them to the redundant employees firstly. If they genuinely are not suitable for those roles, we may then look to open up the search to filling those vacancies from the existing workforce or even possibly externally. And now there may be reasons beyond an employer's control as to why they can't offer a vacancy to a particular employee. Client requirements are particularly important here, and an employment tribunal has made it clear that if a company who is funding a particular post or there is a condition on winning the contract that a certain individual delivers that piece of work, it's very difficult to interfere with an employer's decision to select a particular candidate for filling that role. We did say we'd talk about trial periods as well. So if an employee does accept an offer, it may be subject to a statutory 4-week trial period if, according to the legislation, the capacity in place in which the employee is employed and the other terms and conditions of their employment differ wholly or in part from the corresponding terms of the previous employment. So if there's any material differences essentially between the roles, we do need a 4-week trial period. If that's successful, the ending of the contract is deemed not to have been a dismissal, so the employee continues, not entitled to a redundancy payment, and the continuity is preserved. If the trial is unsuccessful, the employee will be regarded as dismissed for redundancy pay purposes at the date when the original contract ended. And if the employer refuses to allow a trial period, again, that could render a dismissal unfair. So in parts 3 and 4, we're going to move on to a refusal of suitable alternative employment. We're going to look at the factors which are taken into account when determining whether a refusal is unreasonable or not. In the meantime, if you do need any further support in relation to redundancy or restructure matters, do get in touch, employmenthub@chadlaw.co.uk. Thank you.